We're going to have some instant analysis now from Russell Wheeler, who joins us now from the Brookings Institution on the phone. Mr. Wheeler, thank you very much for joining us. What is your take on this?
Well, this is a much less dramatic decision than I think some people were expecting. The decision was 7-1. Justice Ginsburg dissented very briefly. Justice Kagan didn't participate because she'd been involved in the case as Solicitor General. But you have a majority opinion, which basically says a little more than this, that the Court of Appeals failed to apply the level of strict scrutiny, which is a legal term, when it upheld the university's race-based admission policy. You had Justice Kennedy writing the opinion, and as I say, concurrence from not only the so-called conservative justices, but also Justices Breyer, Sotomayor. So, all things considered, I think this is much less than people thought were going to meet the eye today.
Russell, this is Ashby Jones. It has to be, a defeat, at least for the time being, for conservatives and others who thought that maybe the Supreme Court would strike down racial preferences, the very notion of these in higher education altogether. But schools, public universities across the country must be breathing easier because a lot of them have set up very sophisticated types of affirmative action programs, and so they must be, and they would have had to have been dismantled had the court ruled differently today. Can you talk a little bit about the broader implications of this case, at least for the moment?
I think the broader implications are that the Grutter decision back in about 10 years ago still stands, and basically what that says is that diversity in a student body is a compelling state interest, and universities can use plans to achieve that diversity as long as they pass these rather strict standards of review. But the court said, for example, the reviewing court must ultimately be satisfied that no workable race-neutral alternatives would produce the educational benefits of diversity. But what that's saying is that people who thought that the court would just overturn this former decision, they are disappointed because the court has affirmed the decision. It just said it wasn't applied properly here.
Okay, so Russell, would you say it's a loss for everybody or a victory for everybody? Because it's sort of in that neutral zone. I mean, do you think a lot of people are going to be going around and saying, "Hey, that still backs us," or on all sides?
No, I think it depends on who you're talking about. Obviously, there are, you use your word, conservatives. Conservatives will be disappointed by this because they were hoping the court would say any kind of race-based consideration is never justified, and the court didn't say that. So I'd say the victors, if you want to put it that way, are not only the University of Texas, but the many other state universities who filed amicus briefs here, as well as other, as in the Grutter case, other corporate interests and civil rights interests.
Okay, great stuff. Thank you very much, sir. Russell Wheeler of the Brookings Institution coming to us on the phone there. We thank you for your time. Final words from Jess Brevin, our Supreme Court correspondent. Jess, your thoughts?
I think that it's significant that this court, which is very different than the Supreme Court was in 1978 or even in 2003, has affirmed the concept of racial and ethnic diversity as a compelling governmental interest, something that Justice Kennedy has always accepted, if never fully endorsed, at least the tools that universities have used to attain them. If this case goes back, the university is going to have to show why it's necessary to use racial classifications to get that diversity. But it is the Supreme Court with a fairly broad majority once again endorsing the idea that diversity itself is important and is constitutionally valid as a significant government objective. So that, I think, is the bottom line here.
Okay, good bottom line. Thank you very much, Jess Brevin, Supreme Court reporter, and thank you, Ashby. Your final thoughts?
No, I think it's a surprising decision. I don't think anybody was quite prepared for this kind of ruling. It's a narrow ruling, and it could, as Jess said, could be back up in front of the Supreme Court. So it's sort of a stay-tuned moment. But for now, affirmative action lives on.
It lives on. Thank you very much, Ashby Jones. I'm Simon Constable, and that was the News Hub special here on the Supreme Court decision. We'll have more coverage on this on WSJ.com. Have a great day.